All right, boys and girls, we are back with section 4 of our investigations course, which is all about searches, which is one of my favorite topics within the criminal justice field. So, first, as always, we start off with our funny internet picture of the day. Aren't they cute? I just know that I'm gonna die because I saw something cute like that and wanted to go pet them. All right, so searches. Searches and seizures, and a seizure can mean a seizure of property or a seizure of a person, as in an arrest. They're guided by the Fourth Amendment to the United States Constitution, which I'm paraphrasing here because I can't remember the exact wording, but it's something along the lines of people shall be protected from unreasonable searches and seizures, which means that any reasonable search or seizure is allowed, and unreasonable searches and seizures are not unless officers have a warrant. And we're going to talk about a few other exceptions to the reasonableness requirement here in a few minutes. But probably the most important court case when it comes to Fourth Amendment issues in the United States history was Katz versus United States in 1967. Katz was a gambler, and he knew that he probably shouldn't make phone calls to his bookie or the person who took his bets from home. So he would go in front of his apartment where he lived in Las Vegas. There were 3 phone booths, and the old style phone booth, like in the picture there, that have the closable doors, which becomes important later on in the story. So the FBI is watching Katz. They want to arrest him and charge him with interstate gambling violations. So they put a recorder in the ceiling of the phone booth. And prior to this, many years before this, the Supreme Court had ruled that it's only a Fourth Amendment violation if you touch somebody's person, house, papers, or effects, which is language directly out of the Fourth Amendment. And as such, if you didn't touch or modify or look at any of those 4 things, Fourth Amendment didn't apply. So they put a recording device in the ceiling of this phone booth. Katz goes in, he makes his phone call, and the FBI records him doing it. Now, importantly, when he made these calls, he had shut the door behind him. So at trial, of course, he tries to have this evidence suppressed because it was a violation of his Fourth Amendment rights. The district court said it wasn't a violation of your Fourth Amendment rights. Nobody touched your person, your house, your papers, your effects. This was a recording in a public telephone booth. But Katz appealed, and it went all the way to the Supreme Court. The Supreme Court said, you know what, Katz? You're right. Your privacy was violated. From now on, the Fourth Amendment doesn't just apply to those person, houses, those 4 things. The Fourth Amendment applies anytime a person has a reasonable expectation of privacy. And this has been modified a few times since then, but that's the core part of that still stands in U.S. law today. Anytime a person has a reasonable expectation of privacy, police have to have either a warrant or one of the exceptions to the warrant requirement, which again, we're going to talk about here in a minute. So, one of the things that police need before they can get a warrant is probable cause. And probable cause is one of those kind of, it's not super well defined, and there's constantly court cases about what exactly qualifies as probable cause. Does that meet the standard? Does that not meet the standard? And so it gets a little bit into, confusing gray areas. But what we do know about probable cause is that it's a level of proof that is above reasonable suspicion, which is a relatively low level of proof, but it's not as high as beyond a reasonable doubt, which is what we need to secure a conviction in a criminal trial, right? So it's less than that beyond a reasonable doubt, but more than just the reasonable suspicion. And it looks at the totality of the circumstances. what the officer sees, what the officer hears, what the officer understands, what happened before, what's currently happening now. All of these things, everything comes together to give the officer either probable cause or no probable cause. And so one of the things that, there's been numerous Supreme Court cases about what constitutes probable cause and what doesn't. And every opinion gives a little bit different or a little bit more information about what constitutes probable cause or doesn't constitute probable cause. So I Googled and I found this quote here. Given the information available to the officer at the time of your arrest, would that information cause a reasonable and cautious person to believe that a crime was committed? So again, that's a little bit vague, but that's essentially what we're looking for when we say probable cause. And most of the time, we can use probable cause to make an arrest. We can use probable cause to apply for a warrant, or in some cases, we can use probable cause to do a search. And again, we're going to talk more about exactly what that means. Another thing you have to understand before we start talking about these particular requirements for searches or not searches, what does constitute a search, what doesn't constitute a search, if it's a search, is it reasonable or unreasonable? All these things come into play. But one of the things we have to talk about before that is what's called plain view. And this gets a little more complicated later on, but the basics of plain view say that if an officer is in a place he or she is legally allowed to be, they haven't gone off, they're not trespassing in your house, they're not doing anything they're not legally allowed to do. If they can see something from where they're standing and it's clearly contraband or illegal in some way, that is not a search. Or I should say it's not an unreasonable search. So the Fourth Amendment doesn't apply. So in other words, if an officer is walking down the street and they look in somebody's front window and they see what's there in the picture, which is very obviously in most states as of time of recording, an illegal substance, that's not a search. So they didn't need a warrant to be walking down a public street or a public sidewalk and look in somebody's window that's open like in the image there and see that very plainly contraband. Fourth Amendment doesn't come into it. Now, this also applies to your other senses. Touch, smell, hearing. If the officer is in a place they're legally allowed to be, doing a thing they're legally allowed to be doing, and any of their senses picks up something that is obviously illegal, obviously contraband, or in the case of hearing, obviously criminal discussions, they don't need a warrant. They're just allowed to hear what they hear and see what they see and smell what they smell, and that doesn't constitute an unreasonable search under the meaning of the Fourth Amendment. And this is going to come into play later. So remember that plain view information, because that's important. That kind of comes back in a lot of different places throughout when we're talking about the Fourth Amendment. So, of course, a search is always reasonable if you have a warrant. But not just a warrant, a valid warrant. Valid warrants have to be signed by a neutral magistrate, i.e. some kind of judge. And they have to be neutral, i.e. they can't have any kind of vested interest in that search or seizure or whatever that you're getting the warrant for. So, for instance, police are applying for a warrant to search the house of the judge's ex-wife. That's not a neutral magistrate. So they would have to go to a different judge. Say, Judge, I'm sorry, I can't get you to sign this warrant. You are not neutral in this case. I have to go to somebody else and get them to sign this warrant. The warrant application has to, according to the words of the Fourth Amendment, has to particularly describe the places to be searched and the things to be seized. So, in other words, and that particularity is important when the warrant is being executed. So, for instance, let's say the only thing we're looking for, the only particular item we are searching for in this search warrant is a stolen motorcycle. We're going to search Bob Smith's house at 12345 Main Street. That's the place to be searched. And the particular things to be seized or the things we're looking for, stolen motorcycle. We go into Bob Smith's house. We're only allowed to look in the places where a stolen motorcycle might be. So in other words, if somebody starts looking in the kitchen drawers, that isn't covered by the warrant, because we're obviously looking for something there that isn't listed under that particularity requirement of writing a warrant. That's why most police, when they are searching for, say, a stolen motorcycle, in addition to the particular things to be seized, they'll say stolen motorcycle, the keys to the stolen motorcycle, motorcycle parts or pieces that may have been removed from the stolen motorcycle, things like that, to give themselves a little bit more leeway as to where they're allowed to search and what they're allowed to be searching for. Usually these warrants are for a set amount of time. So you apply for a warrant, you get it, but it's only valid for, say, 7 days or 14 days or something like that. By default, most warrants in most jurisdictions have some kind of time limit, and they're usually measured in that kind of, a week, maybe a month if the police are lucky, that kind of time frame. They're also usually again, by default, only for set hours. So the warrant might say this search warrant is good for 7 days and must be executed during daylight hours, or between the hours of 7 a.m. and 6 p.m. or something like that. These can be expanded depending on the specific facts of the case, but unless there's some reason to do that, the judge is going to say, no, you have to do it during these hours, right up until the point the police are able to say, look, we have this particular reason based on the facts of this particular case where we need to do it at night, or we really want to do it for reasons of public safety. We really want to execute this search warrant at 5 a.m. or something. If they can articulate a valid reason for doing so, the judge is free to expand that amount of time or the hours when the warrant is going to be served. But by default, there are limits on when and where and how those can be served. Another default is what's called the knock and announce requirement, meaning that police are legally required to walk up to the door, knock on the door, announce their presence, and give a reasonable amount of time for the person to come and open the door. What exactly is a reasonable amount of time? 20 seconds, 30 seconds, something like that. But they have to knock loudly, announce themselves. Hi, it's the Johnson City Police Department. We have a search warrant. Come open the door. And they have to wait, give the person a reasonable amount of time to come to the door and open it. Unfortunately, there have been instances where that knock and announce requirement has let the occupants of the dwelling prepare in a violent way for the police to come in and resulted in police injuries. Now, because of this, there are such things as knock and announce exceptions. So police can apply for what's called a no-knock warrant, which means that when they're applying for the warrant, just like with the hours and the amount of time the warrant is good for, they can say, Judge, based on the facts of this case, there is a particular reason why we want to not give the person time to either destroy evidence or to set up a violent defense of the home or business, whatever they're searching. So as such, we would like a no-knock warrant, which are definitely a good thing in some circumstances, but there's a national controversy because many people believe that these no-knock warrants, A, are being used way too often, and B, result in the occupants of a dwelling or a business or some kind of building not knowing it's the police who are busting in. And when they don't know it's the police, they have the right to defend themselves, so they start defending themselves, and then the police get injured, but then the police start defending themselves, and lots more people get hurt. So it ends up in more people getting hurt rather than protecting people, which is the point of why they're supposed to be used. So there's a big controversy right now about no-knock warrants, and whether they're used too much, whether they increase safety or decrease safety. But you can look up that kind of thing elsewhere. Another thing we can do, if, again, we have the particular requirements or the particular facts of the case to justify it, is do what's called an anticipatory search warrant. Normally, a search warrant has to kind of say, we believe there is evidence of the crime in this place right now, and we want to go search it. An anticipatory search warrant is similar, but instead of saying we believe there's evidence of the crime in this place right now, it's we believe that there's going to be evidence of this crime at this place at some point in the future. So for instance, if the police got word that there was a stolen material or smuggled contraband coming in on a ship, and the ship is currently at sea, but it's due to dock in 3 days, police might go to a judge and say, look, the ship hasn't docked yet, but we have reason to believe there's smuggled contraband and container number such and such on this ship, so can we get a warrant, not for right now, but for 3 days from now? And again, that's within the judge's kind of ability to grant one of those special search warrants based on something that will be somewhere at a future point in time, not exactly right there, right this second. So I'm going to go ahead and take a break real quick. Be back in just a moment.